Showing on Law Weekly today, we take another perspective on the anti-graft war and other issues. We speak to Senior Advocate of Nigeria, Ade Adedeji. As we count down to the elections of the Nigerian Bar Association, some legal practitioners share with us some issues affecting the bar and the legal profession and what kind of president they think can take on these issues, plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shieli. My guest, Ade Adedeji, first studied sociology before going back to study law at the University of Lagos. He also had his master's specializing in company and commercial law from the same university. He was called to the bar in 1988 and conferred with the prestigious rank of SAN in 2015. I began this interview with his views on the anti-graft war of the federal government.
Of course, the war against graft took off in a way that provided us with an expectation that something big and something good is going to happen. Yes, there was good intention, but no sooner did we discover that there was not a coordinated plan about it. It was not properly articulated in terms of how to implement the policy of the government to follow through on anti-corruption. And that is the fallout. That is why we're experiencing what, of course, we're experiencing now. It's unfortunate, but one would have thought that the government should have articulated a position and should have actually found a way of carrying everybody along to the extent that they should have involved, other institutions, other arms of government, for instance. We found ourselves in a situation where the executive thought they could fight the war alone, but of course, from what has played out, we have now realized that they got it wrong right from the start, unfortunately.
What suggestions would you give for making the war against graft more effective and to carry the other arms of government along, like you've mentioned?
My opinion, and this is very personal, is that no single tree can make a forest, and to that extent, in fighting corruption in this country, particularly because this is something that has gone deep into the fabrics of the society, it is imperative that the judiciary should be directly involved, the legislative arm of the government should be involved, and the press should be involved. And to involve all these other areas, it is necessary that they should be sensitized and they should be carried along. I think the government, that is the present administration, no doubt about it, they had good intention, but they put the wrong foot forward. How did they do that? They did that when they thought that, yes, they could do it alone. There's no way anybody could fight this kind of battle alone. Unfortunately, we have to figure out how to start all over again. But definitely it is a battle that we have to fight.
Let's move on to another issue, closely related though. Do you think that the time has come for the country to have more specialized courts for different offenses generally?
Well, this has been going on for quite a time, this debate as to whether or not we should have specialized courts for this and for that. My opinion is, simple. I think, yes, in certain areas, we need specialized courts. But we have to be very careful. We should not equate judiciary with general law practice. In general law practice, of course, there's a strong advocacy for specialization in different areas of the law. And of course, that is understandable because law keeps, expanding and all that. But when it comes to judiciary, we have to be very careful. We can't have specialized courts for all the areas of practice. We can't. It simply, doesn't make sense. And from experience, because now we have industrial courts, of course, we have, all these other courts. It makes practice a little bit boring, and we need robust, kind of judiciary. A situation where you have certain courts just dealing in just one area of what I call a huge and fledgling, issues and all that. It's definitely not good enough. But of course, that is without prejudice to the fact that yes, in certain areas, yes, I would say constitutional law, yes, of course, we need constitutional courts if that can. But when you're talking, because I hear that, or should I say, it's been recommended now that we should have special courts for banking matters, for insolvency and things like that. I don't think that is necessary. I think insolvency and banking matters, banking issues are just, part of commercial law, which of course should not be because of the need, to expedite matters in courts and things like that. There should be other ways of doing that without necessarily having special courts, to deal with such matters. That is my opinion. That could be the issue of expediting proceedings in special matters could be done through, a more creative way of doing things through the rules of court. Because the reason why people advocate for all the special courts, to be honest, is to kind of fast-track cases, to get cases heard more quickly and things like that.
Because I think it was the CBN governor who called for specialized courts to try loan defaulters too.
Yes, it's because they're concerned that most of these cases, yes, they're stalling, and then, because of the commercial nature, time is of the essence of most of these cases, and for that reason, they're agitated, they're concerned, and they believe that the only way to address the issue is through special courts. I don't think so. I don't think so, because even if they create special courts for all these areas and all that, they'll still have the same problem if certain things are not done. I think that the most important thing is that we should continue to reform our rules of court and, of course, provide resources. When I say resources, I mean resources for the judiciary in terms of courtrooms, in terms of more judges, in terms of, facilities and things like that. These are the things that we need, not special courts.
So you don't think we need specialized courts for corruption cases?
No, we don't. I don't think we do. I don't think we do. Because our judges, well, we all know that they are doing pretty well, and we don't need special judges for this, for, all these areas of the law before we actually get, good results. They're actually good, they're up to the task, and they're doing pretty well, So I don't think we need special courts for all this, because if we do, we'll soon find ourselves in a situation whereby, even for the arrest of goat, we start clamoring for special courts.
Finally, this government has been seemingly unresponsive about obeying court orders. And this is something that worries a lot of lawyers. What do you think that the judiciary can do about this issue?
Interesting. I think this is one question that I believe is out there, and I'm sure you have flogged this question so many times. Now, it's very simple. Our judges must have the courage, and that is all that it takes to actually get government to obey orders of court. I remember many years ago, Justice Jinadu, may so rest in peace. He had a matter, gave an order, the government was not going to comply with the order, and he resigned. So the question is, how many judges can do that today? Not too many. But the truth of the matter is that we need judges that are bold and courageous, judges that are ready to say, look, this is where I stand, and then everybody will rally around. The more we have that kind of disposition to the issue, the better. And if we don't, if we still sit on our hands and we're not going to do anything each time government disobeys the order of court, my own experience, particularly against agencies of government, EFCC in particular, maybe ICPC too, is that they do it as a matter of, practice, not to obey the order of court, unfortunately. They believe so much that they have so much powers by virtue of the fact that they operate under the executive arm of the government. And it is unfortunate, it is very unfortunate that it happens so often because they're not put to task. And what do I mean by that? They're not put to task in the sense that they are supervising ministers or whatever, government generally, do not see anything wrong in what some of these agencies are doing. Unfortunately, it does a lot of harm, not only to the country, particularly the economy, but even to the perception of Nigeria as a country outside, in the outside world. And that means a lot in terms of investment, in terms of, all the other things that are very fundamental, to the progress and development of this country.
What's the role of the Nigerian Bar in all of this, especially as we are electing a new president and new officers?
I'm a member of Nigerian Bar Association, and ordinarily I should not be criticizing Nigerian Bar Association, but the truth of the matter is that we need to do more. We need to go back and reflect on how we used to do it and take a leaf from there. In those days of the likes of Akabasharon, for instance, government will think twice before they do certain things because they know that the bar will stand up and address the issue and rally people, and people will listen. We need to go back to those days when there's dynamism at the bar. We need to go back to those days when the bar speaks, the whole nation listens. And I think we have actually, slowed down a little bit. I think we need to wake up by, of course, getting people in leadership who can actually do it, people that is highly respected, people that when they talk, the bar will listen to start with, and the nation will listen.
Ahead of the elections of the Nigerian Bar Association, scheduled to commence from midnight of the 29th of July to 30th of July, I got some legal practitioners to share with us some of the issues facing the bar and the legal profession, and what kind of president the bar needs at this time.
As the Umbrella Association, housing all lawyers called to the Nigerian Bar, the Nigerian Bar Association is yet to attain its full potential or play its vital role in nation building by religiously upholding the rule of law, ensuring good governance, always protecting human rights, and safeguarding the interests of Nigerian lawyers. In my view, the only way that we can succeed in attaining our goals as an association is by choosing the right leadership to steer our great ship, a ship which is full of potential. In a couple of days, it will be time for us to change the narrative. Let us pick a leader who has a proven track record of accountability. We need a leader, or we should yearn for a leader who will uphold the rule of law at all times and in all circumstances, even against popular demands. We require a leader who would ensure a bar that caters for all its members, regardless of age at the bar or rank. We need to set aside our stereotypes. We need to think and pick without sentiments.
The president of the Nigerian Bar Association should be a person who can identify with the various categories of lawyers who constitute Nigerian Bar Association, be they the young lawyers, the female lawyers, the lawyers with disabilities, and what have you. He or she must be a leader who can make lawyers of each of these categories to feel at home and have a sense of belonging to the Nigerian Bar Association. And the president of the Nigerian Bar should also be in touch with the current digital world, because we just can't afford to be running an analog legal practice in a digital era. And the president of the Nigerian Bar Association should have the charisma, the audacity, and the moral and legal standing to challenge bad governance.
The NBA is by far one of the most organized associations in the world, and the leadership of the Noble Association must first and foremost work towards uniting all barmen. Cases of factional leadership in the NBA should not arise in any part of the country. Secondly, the welfare of all barmen must be a priority to the leadership of the NBA. The young lawyers are the most vulnerable as far as the issue of welfare is concerned. The leadership must ensure that young lawyers are adequately paid their entitlements by their employers. Young lawyers must necessarily be protected against employers who want to exploit them, particularly our female colleagues who are victims of sexual harassment. The leadership of the NBA must continue to ensure that young lawyers are protected in this area. I think anyone who wants to lead the association should have some of these things in mind, and they should be able to convince us that they have some of these plans for us, so that we can all go out to vote for them as the NBA elections come closer.
The next president is expected to be a strong partner, a strong ally, because training of future lawyers cannot be done successfully without the input of the Nigerian Bar Association. In the area of mentoring, that is sending our students on externship to learn from law firm, to learn from the courts, there must be that synergy between the legal profession and the outside world. And the NBA is the mouthpiece of the legal profession to the outside world. Also, in terms of infrastructural overhauling and funding, the law school, the universities, faculties of law ought to be properly funded. So it's expected that the next MBA president will partner very strongly with Alumni Association of the Nigerian Law School and the faculties of law across various universities to do what? To ensure that the alumni contribute very strongly, especially to technological advancement in this era. We are getting to a new normal now, and this new normal can be successful only if infrastructural facility and technological equipment are mobilized en masse into our various law schools and law faculties.
We need a bar that is responsive to the yearnings and aspirations of Nigerians. We need a bar that talks about integrity. And our president should be somebody who has no baggage, who is able to look into the eye of the authorities and speak truth to power. The bar has been the bastion of democratic precepts in Nigeria, and we have lost that for some time. So I believe that the person who should occupy the office of the president of the Nigerian Bar Association should be a no-nonsense man. Should be somebody who should be an activist, ready to galvanize lawyers across the country, across tribes, across religions, and be able to insist on respect for the judiciary, be able to insist on autonomy for the judiciary, be able to insist on proper financing for the judiciary. It should be a lawyer who should checkmate the abuses of our colleagues in terms of processes of law. It should be a lawyer that should ensure that there's discipline within the bar, and that when we say we are fighting corruption, it's truly fighting corruption.
And just before we go, here's a recap of some legal stories we're tracking.
We begin with the report that the Supreme Court has embarked on its annual vacation, which commenced on Monday the 20th of July. A notice from the Court of Appeal indicates that its annual vacation would commence from the 29th of July to the 1st of September. The Federal High Court, through its Chief Registrar, Emmanuel Gako, has also issued a public notice announcing that the court's vacation for the year 2020 shall commence on Monday, July the 27th, 2020, and would end on Friday, September the 25th, 2020. In line with the court's tradition, the registrar said vacation courts would sit in Abuja, Lagos and Port Harcourt divisions to cater for cases of extreme urgency only. But before the vacations commenced, a federal high court in Abuja ordered the issuance of summons on the former Minister of Petroleum, Desiani Alison Madueke, in order for her to appear before it and answer to a money laundering charge filed against her by the Economic and Financial Crimes Commission. Justice Ijeoma Ojukwu made the order in a ruling on Friday on an ex parte motion brought by the EFCC. The court ordered that the summons should be published on the website of the Commission and a national daily in a conspicuous manner to ensure that Desiani, who is said to have fled to the United Kingdom, is aware of the invitation. Justice Ojukwu then adjourned till October the 28th after the annual vacation for Desiani to attend court for the purpose of her arraignment on the pending money laundering charge. The EFCC, in a document filed along with the motion ex parte, said it sought to question Desiani without success in relation to many allegations against her, including her role as the Minister of Petroleum Resources and her role in financing the 2015 general elections to achieve a certain outcome. In Lagos, a federal high court on Friday adjourned until October the 29th, continuation of hearing in a suit filed by a company, Top Water Piers Limited, challenging the nullification of its concession over the National Theatre complex. The plaintiff described itself as a special purpose entity for the acquisition of the management right over the National Arts Theatre and its undeveloped lands in Lagos. The plaintiff's counsel, Chijioke Okoli, Senior Advocate of Nigeria, wants the court to declare as unlawful the termination of its concession over the theatre. Joined as defendants are National Theatre and National Troupe of Nigeria Board, Infrastructure Concession Regulatory Commission, the Minister of Interior, and the Attorney General of the Federation. Also joined are the Central Bank of Nigeria, Access Bank, and Herbert Wigwe. The plaintiff is seeking a declaration that it is unlawful for the defendants to purport to truncate and nullify its rights as a concessionaire of the fallow land at the National Theatre by inducing a breach of its contract. And still in Lagos, a federal high court has suspended hearing in the suit filed by Western Lotto Limited to challenge the alleged infringement on its trademark by 23 rival lottery firms. Justice Chukwuje Aneke suspended the hearing in the suit to await the outcome of an appeal filed by one of the defendants. The suit was filed by politician and businessman Senator Buruji Kashamu against Premier Lotto Limited, popularly known as Baba Ijebu Gaming Limited, and 22 others. Meanwhile, the Federal Competition and Consumer Protection Commission, FCCPC, formerly called Consumer Protection Council, is seeking to be joined in the suit, which it says touches on lottery operations in the country. The chief executive of the commission, Babatunde Rukera, told Justice Aneke that the FCCPC has concerns about certain clauses in the mutual agreement executed between the plaintiff, Western Lotto Limited, and first defendant, the National Lottery Regulatory Commission. And we round up with the report that another federal high court on Friday convicted two men, Uche Johnson and Kingsley Meteke, for producing and distributing substandard engine oil. Justice Oluremi Oguntoyibo convicted them after they pleaded guilty to the offense. She sentenced them to 2 years imprisonment each. The Standards Organization of Nigeria, SON, said the defendant indulged in production of engine oil, which did not meet the mandatory industrial standards. The products were said to have failed to comply with the Standards Organization of Nigeria's Conformity Assessment Program, SONCAP. The convicts admitted to have adulterated 128 drums and 9.45 liters of engine oil. Their 2-year sentence will begin from January 27, 2019, when they were arrested.
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Shele. Thank you for watching.